Thank you, Mr. Speaker. I rose last Wednesday to raise a question of privilege in relation to a report central to this House's deliberations on Bill C-54, the Not Criminally Responsible Reform Act. I have since had the benefit of reading the interventions of the member for Skeena-Bulkley Valley and the Honourable Minister of Justice, and I wish to respond this evening. Briefly, for the benefit of members listening who are unfamiliar with the issue, the government commissioned a report on persons found not criminally responsible last year. This was received last November, when researchers discovered in March an error involving the transposition of data labels. They diligently worked to provide the department with a corrected version. However, after the corrections were provided to the government, a minister continued to cite from the old report in debates, an old report which the government, even after being apprised of the error, tabled in the House. Mr. Speaker, when I indicated when first rising on this point, I thought it very important that the House be provided with the correct numbers in a timely manner. Indeed, the basis of my intervention was that, as a scientist MP in particular, I am impeded in my work when evidence in the form of quantitative information is withheld or concealed. Moreover, I feel that the Standing Committee on Justice and Human Rights was unable to properly study Bill C-54 with incorrect data before it. So I rise today to respond to the intervention on this matter from the Minister of Justice. At the outset, let me state that I appreciate his prompt attention to the matter, and I also appreciate that he decided to not repeat in this House the comments of the spokesperson for his office, as reported in the press, comments that criticized both the researchers and their work and could have unfairly damaged their careers and reputations. Mr. Speaker, it is my intent in my intervention today to argue two things. One is that the government lacked a necessary sense of responsibility, urgency, and rigor in correcting factual errors germane to the debate on C-54, and that this neglect had significant consequences for the work of this House. Secondly, I would like to propose, if you should find that my privilege has been breached, that a commensurate and positive remedy would be one that formally led to a systematic way for ministers and members to correct any significant factual errors presented to this House. I believe that would improve the work of this House for the benefit of all members and for the good of Canada. At the end of his intervention last week, and in response to the request in my initial intervention, the Minister of Justice tabled a report in this place. I thank the Minister of Justice for that. However, and regrettably, that document gives rise to what is potentially a new point of order that, Mr. Speaker, I can only raise now, having seen the document for the first time on Friday. As the journals for last Thursday notes at page 3406, the quote, Minister of Justice laid upon the table a document entitled Description and Processing of Individuals Found Not Criminally Responsible on Account of Mental Disorder Accused of Serious Violent Offenses. And then in parentheses, Mr. Speaker, quote, English text only, followed by the annotation sessional paper number 8525-411-60. Mr. Speaker, I wish to raise two issues here. First, as O'Brien and Bosk note on page 433, quote, any documents tabled in the House by a minister or, as the case may be, by a parliamentary secretary, whether during a sitting or deposited with the clerk, are required to be presented in both official languages, end quote. The citation therein is to Standing Order 32-4, quote, any document distributed in the House or laid before the House pursuant to sections 1 or 2 of this standing order shall be in both official languages, end quote. I do not wish to belabor this point at length, Mr. Speaker, but I note that the Minister sought unanimous consent to table the document, something which he is not required to do by virtue of his being a minister. That said, he did not specify to the House that the document was only in one language. I believe the Minister will agree that all documents tabled in this place ought to be tabled in both official languages of this country, and I must say I found it curious that he sought consent without informing the House of why it was needed. Had he specified he wanted consent to table it unilingually, it is quite possible that some honourable members would not have agreed. Secondly, Mr. Speaker, and this is the bigger issue, the document tabled was not actually the final March report as we know it now to be. Instead, what was laid upon the table was a work product version replete with track changes intact. Track changes is a feature used to manage multiple versions of Microsoft Word documents. While I trust that some members will now appreciate having the opportunity to study a version of the report with correct data, it is regrettable that the Minister did not table the clean, finalized copy with which I am now aware his office was provided on the same day as this version. Nor, Mr. Speaker, did the Minister table a copy in French. Surely the final report in both languages would best suit members in studying the matter and perhaps re-evaluating their position vis-a-vis Bill C-54. In his comments in this place, the Minister of Justice stated that the corrected report had been available online for some time, providing reference to the website for the National Trajectory Project. I would first begin by noting that the version on this website is clean and not the one which the Minister tabled in the House. De plus, j'ai eu l'occasion de consulter ce site web ce week-end. Le ministre a raison que ce rapport y est disponible, mais uniquement en anglais. Aucune version française n'est offerte. Since there is no French version on that website, strictly speaking, I would have to object to the Minister's assertion that, quote, the amended version in fact has been available online for everyone to see, end quote. Indeed, and as I verified with the researchers, no French of the corrected version existed anywhere in the public domain, and to my knowledge, it still does not. The manner in which the Minister tabled the revised research report last week is an illustration of the government's lack of rigor. It is his responsibility as Minister to ensure that the members of this House have the information required to make informed legislative decisions. Rather than tabling the final report, the Minister tabled a unilingual draft version. In failing to provide these updated statistics in a transparent way by tabling a draft report rather than a final report, and then only in response to my intervention, I believe that the Minister has failed in his responsibilities to this House. Because the Minister has shirked his responsibilities, he has violated my privileges as a member. Mr. Speaker, there is a critical contention which is not refuted by the Justice Minister's comments on the matter of privilege. In his submission of last Thursday, he stated, quote, we gave notice that the report had been significantly amended. This notice was only given in an order paper response. The problem, as you can appreciate, Mr. Speaker, is that saying there is an amended report and actually providing the amended report are two separate things. Beyond that, on May 27th, the Minister of Justice said to this House, quote, I referred to some of the statistics in the final report, knowing full well that he had in fact referred to statistics that were no longer in the corrected report because researchers had diligently reviewed their findings, discovered significant errors, and transmitted them to him as soon as possible. Over 2 months after receiving the, quote, significantly amended report, the Minister was referring to erroneous data in what he called a, quote, final report from November 2012. This, to me, suggests an intent to mislead this House. I understand that the Speaker does not generally delve into the minutiae of order paper responses. However, I must note with frustration that the government's response to a question asking for current statistics as part of question 1169 on the order paper, a response that simply pointed to the old report given in Annex 1 would indeed mislead the House and provide members with the impression that the report in Annex 1 was the significantly amended one, when it was in fact the old one. Mr. Speaker, in responding to questions posed in question 1169 on the order paper, such as which people found NCR and released have been convicted of a subsequent offense, and what was the nature of the subsequent offense, the government had the option to use information it knew to be correct. Instead, it chose to respond with information it knew to be incorrect. Mr. Speaker, I'm told you have no role in adjudicating the sufficiency of answers to order paper questions. However, I believe you cannot deny that the government did not use that opportunity to take responsibility and correct important factual errors. Mr. Speaker, I will now focus on one aspect of the privilege point more precisely, the central issue of incorrect data cited in this House. I rose in this place last Wednesday, June the 12th, after routine proceedings. This was my first opportunity since the June 11th global news story about recent citations of incorrect statistics by a minister and a government member. Yet that same afternoon, June 12th, after the global news report and after my question was raised, a witness before the Standing Committee on Justice and Human Rights testifying about Bill C-54, Mike McCormack, the president of the Toronto Police Association, stated the following as recorded by the Blues. And here I quote his citation of the Minister of Justice. Quote, "The Honourable Rob Nicholson provided some interesting facts about persons found not criminally responsible in the House of Commons debate on March the 1st, 2013, when he stated that, and the citation, over 27% of individuals found not criminally responsible have had a past finding of not criminally responsible. 38% of those found not criminally responsible and accused of a sex offense had at least one prior NCR finding. 27% of those accused of attempted murder had at least one NCR finding. And 19% of those accused of murder or homicide had at least one prior finding of not criminally responsible." End of citation and end of quote. Mr. Speaker, this underscores the problem. Ministers' words carry significant weight by virtue of the resources they command and the respect given to their office. But all of these statistics quoted by the aforementioned witness are incorrect. I know it, the minister knows it, and now as of this report being tabled, all English-reading parliamentarians know it. The problem, as I believe you will see, Mr. Speaker, is that the minister's act of informing Parliament did not correct the Hansard record of March the 1st. His assertion that the corrected report could have been found on a website is unconvincing, as that source did not inform certain witnesses, or even government members, such as the member for Cumberland, Colchester, Musquodoboit Valley, who both cited old numbers at committee during its study on this bill. I should be clear that I do not fault the witnesses for their use of the facts as they were provided. I do not believe any of them had any intention to mislead Parliament. I do, however, take issue with the minister only tabling the correct numbers after the committee had reported the bill back to the House, and the use of old statistics by other government members. In particular, regarding the citation of old statistics by the Minister of Natural Resources, the Minister of Justice explained, quote, "The Minister of Natural Resources was provided, as were many government members, with supporting documentation that in error included the statistics." He then added, with respect to the Minister of Natural Resources, quote, "This was nothing more, quite frankly, than an honest mistake not of his own doing, and I hope this addresses entirely the matter pertaining to the Honourable Minister." End quote. While I greatly appreciate the Justice Minister acknowledging that a mistake had been made, I must disagree with the conclusion he draws as to the matter being closed. Indeed, if the Minister of Justice's proposition that all members should have gone online and consulted the corrected report is followed through to its logical conclusion, this obligation would equally extend and apply to the Minister of Natural Resources and all government members. The Justice Minister was quick to suggest that I should do, quote, "a simple internet search." Surely his fellow minister and other government members ought to have done the same. Same internet search. And even the Minister of Natural Resources and his office, if even they were misled, how could regular members of Parliament be expected to discover the true facts? Given that, Mr. Speaker, as of Friday, June the 14th, the report from Dr. Crocker's research group had not yet been translated and therefore had not been tabled in the Standing Committee on Justice and Human Rights. Do we even know if all of the members of the Standing Committee on Justice and Human Rights knew the correct facts when they adopted Report 25 on Bill C-54 on June the 12th, 2013? Returning to the elements of privilege as outlined in my initial submission, the Minister failed to address another point. As I noted, the Minister referred to the November report as, quote, "final," despite having received the corrected report. He again, in his intervention on my question of privilege, used the word, quote, "final," in relation to the November 2012 report. Mr. Speaker, I do believe this misleads the House, The November report is not final if there is a corrected March report. Similarly, the report tabled is not final if it is not the final version submitted, which the one submitted containing Microsoft Word's track changes, is not. Moreover, while the Minister of Justice has indicated a mistake in what was provided to the Minister of Natural Resources, the Minister of Natural Resources has yet to recognize his error before this body. I believe he ought to do so, and more importantly, tell this House whether knowing the actual facts has changed his mind about Bill C-54. As Speaker Milliken has often ruled in the past, and here I cite from a ruling on Monday, October 4th, 2010, quote, "It is also a long-standing practice in this House for the Chair to accept the word of honourable members and indeed their apologies. I agree, but we have not yet heard from the Minister of Natural Resources, personally, one way or the other." In my initial submission, Mr. Speaker, I stated, quote, that I would even consider abandoning this privilege claim if the government were to table the new report in the House and explain why it did not choose to do so when it was first made aware of the correction. While the government did provide a document, not the final report, it did not explain why it had yet to table it, and indeed basically sought to say it had done everything it ought to have done. I disagree. Mr. Speaker, I would like to move now to discuss what I think would be an appropriate and commensurate remedy for any breach of privilege. It is not because I wish to presume to know your decision, Mr. Speaker, but it is because this matter, I believe, can result in a positive legacy for Canadians, and I wish to explain how. As my colleague for Skeena-Bulkley Valley helpfully pointed out to the House in support of my question of privilege, quote, "The 22nd edition of Erskine May Parliamentary Practice also states on page 63, it is of paramount importance that ministers give accurate and truthful information to Parliament, correcting any inadvertent error at the earliest opportunity." Had the ministers, in fact, corrected in an obvious and accessible way the errors that were preserved on the record, witnesses would not have quoted them after my intervention as evidence in committee. Had the record been corrected, witnesses and parliamentarians would have had accurate information upon which to formulate their positions on this gravely important issue. Moving forward, Mr. Speaker, the question becomes whether this matter should go to Procedure and House Affairs, an issue on which we should have guidance from you, Mr. Speaker, regardless on how you rule on the privilege merits, is the obligation on members to correct themselves on important matters, and the means by which this might be done. I believe all members would agree that it is important to, as much as we can, ensure that erroneous so-called facts are not repeated in the public square. I believe all members would agree that the repetition of untruths in the public square can seriously impede members in the exercise of their democratic function as legislators. And I expect that honourable members of this House would never stand by and allow that to happen. Therefore, I believe that if there were a clearly defined process for members to correct any errors they had unwillingly stated on record, they would eagerly seize that opportunity. Like the Minister of Justice's statements from March the 1st, which I acknowledge were made before the new report was provided, the Minister of Natural Resources' comments after the correction also remain on the record. So far, the approach of the House and Chair appears to be that members can, if they so choose, rise on a point of order or rise on a so-called point of personal privilege to correct themselves. It seems there is no formal requirement to do so. The problem, Mr. Speaker, is that in the case of erroneous empirical facts, they may remain on the record, which is permanent, even after perhaps new research has corrected them. Permanent corrections are possible, however, through the process of seeking a corrigendum. Regrettably, Mr. Speaker, there is little guidance on this point, and indeed, I only find a handful of references to corrigenda in Speaker's rulings since 2001. As the parliamentary glossary explains, this is a term used in journals, debates, committee meetings of proceedings, and committee evidence to indicate that a substantive correction has been made to a previous issue. Beyond clerical corrections to bills and corrections to the order paper, there are examples of where a Speaker has ordered, quote, that a corrigendum be issued to rectify the error, end quote. I will concede that these have arisen, it seems, primarily in cases where the transcript does not reflect what a member said. However, I assert that there ought to be clarity on whether a member could rise to seek such a correction where new research, for example, has shown that the empirical facts have changed. As such, it might be appropriate for the Procedure in House Affairs committee to consider whether or not another mechanism should exist for an ex post correction of Hansard by a member who intervened, limited to empirical findings perhaps, to ensure that those who rely on Hansard are not misled. In other words, I accept that the minister did not know of the corrected data when he first spoke. When he was informed later in the month, it would have been ideal for him to rise on a clarifying point of order or to seek a corrigendum. The premise I'm operating under, of course, is that if the minister had the corrected data, he would have indeed cited it at the time. This is not something he has yet said, so I realize it is not an entirely safe assumption. In closing, Mr. Speaker, I believe that this matter is not best resolved by belaboring who exactly said what or placing the chair in the position of interpreting the intent and meaning of words, something you recently reminded the House was beyond the chair's purview. Thus, while other members may seek to extend this matter, I believe we are best served by ministers involved reporting the correct numbers to the House as a point of order or seeking to correct themselves through corrigenda if such is indeed permissible. The words of ministers of the Crown carry significant weight by virtue of the resources they command and the respect given to their office. That is why I believe they have a special obligation to correct themselves. Moreover, each member of this place surely has an obligation to inform himself or herself of the facts before speaking and to correct himself or herself if erroneous information is presented. If that were not our habit, the force and import of debate in this House would be diminished, and the dignity and purpose of this House would be diminished. From you, Mr. Speaker, I would thus seek some guidance whenever you choose to report back to the House as to what is required when a minister realizes that an error has been made. I would also ask you to consider whether it is possible for members to seek correction of their own interventions in Hansard when it is not merely an error of transcription, but rather a correction to an empirical quantity, perhaps with a notation that an amendment has occurred, such as would be appropriate in the cases I cited in my interventions on this matter. I believe that your guidance on such requirements may be a positive legacy of this matter of privilege. I thank you and I thank all members for their attention to this matter.